Thank you. Roll call. Thank you. Thank you. Mr. Lieutenant Governor, Mr. Attorney General, members of the House and Senate, honorable guests, honorable pastors, I appreciate all that's been said. I'm a judge. Normally judges don't speak in public about issues like this. But if I should hold back my opinions at such a time as this, I would consider myself guilty of treason toward my country. And an act of disloyalty to the majesty of heaven, which I revere above all earthly kings. I came here today. I want to thank you for your attendance. I know it's hot. I'll make my comments short. I came here today from Alabama, and as I was traveling, I was reminded of a guy that came back to Alabama came back to Texas many years ago in 1931. It's a guy whose name is inscribed on this county. Colonel William Barrett Travis from Conecuh County, Alabama, came to draw a line in the sand at the Alamo. He took a stand in the face of an enemy that was far more numerous, but he knew that he had to make a statement for the people of Texas and that he would give his life. I hope I don't give my life, but I'm going to tell you this is a very serious matter.
Yes, it is.
There's today another threat, not only in Texas and Alabama, but across our country, where state and federal court judges have overruled constitutional amendments passed by the people of those states.
I bind up a perverse spirit in Jesus' name.
And people have just sat by and watched it out of fear of federal government. But nothing in the Constitution of the United States, nothing in the laws or precedents of the federal courts give federal courts any authority over domestic policy of family and marriage in the state of Texas or the state of Alabama or anywhere else. Now that may sound good. You may say, well, you mean that 30-something states have yielded to federal tyranny unnecessarily? Well, let me quote out of Windsor, U.S. versus Windsor in 2013. The states at the time of the adoption of the Constitution possessed full power over the subject of marriage and divorce. The Constitution delegated no authority to the government of the United States on the subject of marriage and divorce. Haddock versus Haddock, 1909. You see, the law does not allow the federal courts to come into the state of Texas or to come into the state of Alabama and say that your Constitution is unconstitutional and start issuing same-sex marriage licenses, because that authority does not belong to the federal government. Last month, when a federal judge came into our state and through intimidation indicated that all the federal court or all the probate judges of our state would have to issue same-sex marriage licenses, myself and the Alabama Supreme Court said no. Today, no same-sex marriage licenses are issued in our state. But the law is clear. It's clear not only in Alabama, but in Texas as well, that state courts have equal authority and equal responsibility to interpret federal questions. Clarence Thomas in 1993 said it very plainly. He said in our federal system, state trial courts' interpretation of federal issues are just as authoritative as the Federal Court of Appeals in whose circuit they are situated. The Texas Supreme Court has recognized that principle. I quote, Penrod versus Drilling Company Corporation and versus Williams. While Texas courts may draw upon precedents of the Fifth Circuit, they are obligated to follow only higher Texas courts. We've got to go back to an understanding that the state has a dual sovereignty with the United States and that their court systems are important.
Amen.
This great fallacy that's been perpetrated on our communities that everybody now accepts same-sex marriage is simply wrong. Only 3 states have voted by resolution of the people to adopt same-sex marriage. No court has any authority to redefine what God proposed in Genesis. The definition of marriage, if you want it by man, it doesn't come by man, it comes from God. And man's dictionary back in 1828 recognized that marriage is between one man and one woman, was instituted by God himself for the purpose of preventing the promiscuous intercourse of the sexes, for promoting domestic felicity or happiness, and for securing the maintenance and education of children. That still remains today. In 1967, when the United States Supreme Court in Loving versus Virginia recognized the institution of marriage, they said it was one of pursuit of happiness, referring to the Declaration of Independence, which says, "We hold these truths to be self-evident, that all men are created equal and endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness." Recognizing that these rights come from God. And if they come from God and are unalienable rights, they can't be taken away by man. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. If we should sit back now and let this right be taken from us, we would be guilty of the most egregious offense. State or United States Supreme Courts like Justice Kagan and Justice Ginsburg should be recused from sitting on this issue. If they fail to, they violate their own ethical canons of not avoiding the appearance of impropriety. I ask the judges of this state and the justices of this state to stand up for the people of Texas and to do the right thing. Had Colonel Travis decided to surrender at the Alamo, we may very well be called Mexico today. Texas is recognized across this country as a leader in states' rights, as a leader in state sovereignty. If we fail to stand up today, we will dishonor the memory of not only of Colonel Travis, but all those who have died in the history of this great state. May God bless you, bless the state of Texas, and the United States of America. Thank you.